consciously or unwittingly identified the basic structure of our Constitution through Article 255, end of quote. According to Justice Kiage, at page 85 of his judgment, Article 255 of the Constitution, quote, either coincides or nearly coincides with what may be considered to be the basic structure of our Constitution, end of quote. Finally, Justice Cairo and Justice Tuyot are certain in their respective judgments that Article 255 of the Constitution outlines the basic structure of our Constitution. Even if the basic structure doctrine was applicable in Kenya, which we dispute, the absence of clarity on what the basic structure is would create much legal and constitutional difficulty. This is a matter that we humbly urge this court to clarify with finality. The second issue I wish to highlight relates to the question of the remit of popular initiative in the constitutional amendment power under Article 257 of the Constitution. In our view, the provision does not discriminate as between private citizens and public or state officers. The route is available to registered voters, who obviously include the president and public or state officers. Our study of the history of this provision is that the popular initiative route was meant to curb the monopoly of Parliament on matters constitutional amendments. It was not meant to exclude certain registered voters or citizens because of their positions or standing in society. And here we rely on the final report of the Technical Working Group, K, of the Constitution of Kenya Review Commission on Constitutional Commissions and Amendments to the Constitution, which recorded as follows, and I quote, "The committee introduced a novel idea called popular initiative. The committee explained that their intention was a starting point towards curbing dictatorship by Parliament," end of quote. And that report is available in volume 18 of our bundle of authorities, page 2622, and the quotation will be at page 4 of the report. Again, my lords, my ladies, the learned judges do not agree on the implications of their finding that the president cannot use the popular initiative route to amend the Constitution, or the options available to a president who may wish to spearhead constitutional changes. In paragraph 490 of its judgment, the High Court told us that the president can use the parliamentary initiative route through the Attorney General. Justice Musinga agrees with this position in paragraph 347 of his judgment. Lady Justice Nambuya in paragraph 99 of our judgment, and Justice Cairo in paragraph 81 of his judgment agree as much. On his part, Justice Kiage holds in paragraph 109 of his judgment that the president is under duty to obey but not change the Constitution. So according to Justice Kiage, changing the Constitution is tantamount to disobeying the Constitution. Lady Justice Okwengu, Lady Justice Sichale, and Justice Tuyot do not express themselves on these matters. This absence of clarity, my lords and my ladies, is clearly problematic. In addition to the foregoing, the learned judges do not consider the consequence of their finding to a president who, having been elected on the platform of arguably necessary constitutional reforms, finds himself facing a partisan and hostile parliament, perhaps because he has a minority in that parliament, or because he was elected as an independent candidate. Justice Kiage, the only one who expresses his view on this point at page 109 of his judgment, terms this situation as hypothetical. We humbly submit, however, that such situations are a real possibility under our constitutional architecture and therefore require contemplation and an answer which we call upon you, my lords and my ladies, to provide. The third and last question, which I wish to briefly highlight, relates to the question of presidential immunity from civil court proceedings. And here the majority in the Court of Appeal held that civil proceedings can be instituted against the president during his tenure of office in respect of anything done or not done contrary to the Constitution. I wish to highlight two obvious problems with this. First, in order to determine whether the president has done or not done anything contrary to the Constitution, there has to be a judicial process. And this defeats the whole essence of immunity, as the president would have to participate in the process to prove his innocence. Second, immunity from legal process recognizes, as a matter of common sense, that the holder of immunity, in performing his functions, engages in conduct that may expose him or her to legal process. If therefore there was the expectation that the office holder's official conduct must always be perceived as lawful, then the whole question of immunity would be redundant. My lords, my ladies, my other colleagues acting for the Honorable the Attorney General shall endeavor to demonstrate to my lords and my ladies additional problems with the findings of the learned judges of the High Court and the Court of Appeal. At this juncture, may I, with your permission, lords, my ladies, invite Senior Counsel George Oraro, followed by Mr. Kamau Karori to present the arguments, and Mr. Nyamodi will deliver our rejoinder at the end of the proceedings. Many thanks and most obliged.
Thank you, Chief Justice, members of the court. The Constitution of Kenya commences with very powerful words, and that is, we, the people of Kenya, acknowledging the supremacy of the Almighty God of all creations, and exercising our sovereign and inalienable right to determine the form of governance of our country, and having participated fully in the making of this Constitution, adopt, enact, and give this Constitution to ourselves, and more importantly, to the future generation. Article 1 of the Constitution thereafter contextualizes the sovereignty of the people and further asserts that this sovereignty can be exercised either directly or indirectly at Article 1(2). The people of Kenya have further delegated their power to state organs, including the judiciary, as specified in Article 1(3). But the exercise of such delegated power must be strictly in accordance with the Constitution. In the result, the people of Kenya, by their constitutional text, reserved the sovereign power to be exercised directly where it has not been delegated or it is not being exercised through democratically elected representative. And it is in this context that in the CKRC report at paragraph 744, and that is found in volume 13 at page 1851 of our list of authorities, at paragraph 7, they state as follows: all power and authority should derive from the people of Kenya, and the people should be governed through their will and consent. The people reserve to themselves all the power and authority that they do not expressly delegate to the state and its organs. So ours is a participative constitution in which the people are fully involved. It was on that account that in formulating the provisions for amendment of the Constitution, it was recommended at paragraph 746 of the CKRC report. And you find this in page 851, volume 13 of our list of authority. They stated that a number of key constitutional issues should be enshrined in the Constitution, that they should be amended only by a referendum, so that a referendum in accordance with the Kenyan Constitution as mandated by the people was an exercise of sovereign power and not a delegated power. It is not strange that that has been incorporated into our Constitution, and indeed, in the famous case which has been relied on to justify the basic structure doctrine, the case of Njoya, it is always stated that at that stage the basic structure doctrine was recognized, but Njoya also recognized the textualization of the sovereign power. And you'll find that in our list of authority at page 24, where in Njoya, this is what Justice Ringara found. The second stop is recognition that sovereignty of the people necessarily betokens that they have a constituent power, the power to constitute and or reconstitute, as the case may be, their framework of government. That power is primordial one. It is the basis of the creation of the Constitution, and it cannot therefore be conferred or granted by the Constitution. Indeed, it is not expressly textualized by the Constitution, and of course it need not be. If the makers of the Constitution were to expressly recognize the sovereignty of the people and their constituent power, they would do so only ex abundante cautela. And that is what they did in our Constitution. This case was in the repealed Constitution, and in the new Constitution, they now ensured that they textualize the sovereign power of the people. The Constitution of Kenya thus places the people and the exercise of their sovereign power at the core of constitutional operation and enforcement. And for that purpose, it incorporates a very a permissive amendment provision under Article 250, granting the courts the power to advance the contemporary aspirations of the people with this court as the final arbiter. And that is where we are. The direct democracy, which is referred to at Article 1(2), is exercised through the national values and principle of governance pursuant to Article 10, public participation in legislation for Parliament, Article 118, and for county assemblies, Article 196, and finally, in constitutional making through popular initiative, that is Article 257, and of course, public discussion in amendment by Parliament at Article 256(2), and finally, that sovereignty is exercised through a referendum to amend those matters which have been specified at Article 155(1) by the provision of Article 255(1) by the provision at Article 255(2). It is because of this peculiar character of our Constitution that this court, in dealing with the amendment power under Article 259, had the following to state in its decision in petition number 13A of 2014, Judges, Magistrates Vetting Board, and 2 others versus Center for Human Rights and Democracy, and 11 others. This is what this court had to state. It stated that although certain jurisdictions such as India and Germany have perceived judicial review as an immutable structure of their constitution, and hence the basic structure doctrine, this jurisdiction do not have constitutions that are as unique as Kenyans. We must ask whether this foreign jurisdiction we seek reliance upon have constitutions, and if they do, whether these constitutions have provisions akin to Articles 1, 23, 159, and 259, and I would add to that 257 and 255, which emphasize the sovereignty of the people, or whether they have principles and values like the ones found at Article 10, which apply to the interpretation and application of the Constitution, or whether they have legislation similar to our Supreme Court Act, which introduces Kenya's historical context into the interpretation of the Constitution. If the answers to those questions are in the negative, and indeed they are, then the common law doctrines found in other jurisdictions, foreign cases, and foreign constitutions must be interpreted in such manner as to reflect our modern Constitution and our unique conditions and needs. And that's what I'm requesting this court to do. Look at this purported introduction of limitation to the Constitution by a foreign doctrine and find out whether in the context of Kenya today, this doctrine can apply to what the people had determined to be applicable to them. That notwithstanding, both the High Court and the Court of Appeal found that there is a limitation to the constitutional amendment powers under Chapter 16, Articles 155, 156, and 157, read together with Article 1 and with very permissive provisions under Article 259. The said finding was based on the following grounds. First and foremost, the court found that the basic structure doctrine is accepted in Kenya following the decisions in the case of Njoya and Attorney General, the case of Onyango and 12 others versus Attorney General, and you will find that at page 28 to 121 with the relevant portions of the judgment at pages 67 of volume 1 of the Attorney General's authorities. These were all cases decided under the repealed Constitution, and I will go to that in detail, but I would start by commenting that under the repealed Constitution, there was a single tract amendment provision which placed all the power on the Parliament to affect amendments. Under that Constitution, Parliament was purporting from time to time to overturn the basic structure without reference to people, and therefore, in that context, the basic structure doctrine applied. But does it apply in our current context, which has a multi-tract amendment provision, as we will show you? The other decision they relied on was decision in Commission of Implementation of the Constitution versus National Assembly of Kenya and two others. It was a decision by my learned judge when he was in the High Court, and it was based on an attempt by Parliament to alter a provision which was entrenched under Section 151, and the issue there was limited to the power of Parliament to amend. Now, contrary to those decisions, the courts subsequent to the amendment of the Constitution and before the decision in this case, in the case of Priscilla Ndululu Kivuitu and another suing as personal representative of Samuel Mutua Kivuitu and Kiara Mutu, my ladies, you find that at page 142 to 182 and at page 177, found that the basic structure doctrine is not applicable to Kenya in view of the amendment provisions under the new Constitution. Though this finding was arbiter, but that was the finding of the court, 3 judges. You find that at page 142 to 182, and the relevant filing is at page 177, volume 2 of our authorities. The Court of Appeal has been more succinct, and in the case of Senate and 48 others versus Council of Governors and 54 others, 2019, you find that at page 183 to 202, at page 154 of volume 2 of our list of authority, they expressly found that Casavananda no longer applies to Kenya in view of the new constitution, a bench of 5. Again, in the case of Attorney General and another versus Randunzai, Rua, and five others, they came very succinctly and expressly, and now clearly stated that all the provisions of the Constitution were amendable so long as Article 255, 256, and 257 are followed. And you will find this case in our supplementary bundle. The relevant finding is at page 19. Due to time, I will not read it, but if I get a little time, I'll go through it. Now, following that, there was clearly a contradiction between the position now held by the court in this case and the earlier decisions made by the Court of Appeal, which were never distinguished in their decision. It now falls upon you as the final court, and the court granted this power to reconcile these contradictions and come up with a very clear position whether there is any limitation to amendment power as granted under the Constitution. My humble submission is that there is not, because as the SG had stated, the provision of amendment under the Constitution are very clear. The other ground which they relied upon was that an amendment provision in a constitution are secondary powers granted by the exercise of primary constituent power and cannot therefore alter or amend what has been created by people exercising their primary constituent power. This is based on a constitutional doctrine which was later advanced to the doctrine of basic structure as articulated in the case of Casavananda in India. However, the Kenyan Constitution has distinguished between the matters which can only be amended by Parliament or popular initiative followed by referendum, and those which can be amended by Parliament and therefore not listed under Article 255(1). The Kenyan Constitution provides a strict procedure for those matters which have been entrenched under Article 255(1), and which can only be amended whether by Parliament or popular initiative, but through a very intensive process involving consultation with the people, and that's the only place in the Constitution where the issue of public discussion is incorporated. Article 256(2) requires that before Parliament passes any constitutional amendment, there has to be publication and public discussion. And that's not the end. Parliament has then to pass it with requisite majority, and it is only after it is passed by that requisite majority that it is then taken to the people for a referendum. And that referendum has a threshold higher than presidential elections. It is therefore clear from those provisions that people are not only involved in a referendum, but they are involved from the onset, from the setting up of the bill for the constitutional amendment. They must be consulted and they must discuss. And it is upon that consultation and discussion that it can then now be passed by Parliament. And if Parliament passes it, then the final stage now becomes the referendum. This is a process which doctrinally has been recognized in constitutional theory and applies in all cases where the design of a constitution contains this type of structure. And it is referred to in the book Making, Breaking, and Changing Constitution by Professor Richard Albert as follows. You find that book at volume 18, pages 2527 to 2530. And it says this: the comprehensive multi-track pathway is designed to avoid the problem of obstruction by distributing amendment power to different actors. The designers can create different procedures for amending the Constitution and others for dismembering it, the former requiring a lower degree of agreement than the latter. What emerges is a hierarchy of constitutional importance, with some parts or principles of the Constitution assigned to amendment procedures and the others to dismemberment procedures. And that's what our Constitution has done by Article 255(1) and 256. Yaniv Rosnai, in his part, in his book on constitutional amendments, found at volume 2, page 1548, states as follows: constitutions have different procedures for constitutional amendment. Not only do entire constitutions differ from one another in their mechanism, actors, and procedures involved in the amendment processes, but also the same constitution might incorporate different procedures for amending different provisions and principles, like ours. This section therefore argues that one ought to regard constitutional amendment powers not in a binary manner, limited or unlimited, as the Court of Appeal and the High Court have done, but rather as a spectrum of a scope of amendment powers. The more similar the democratic characteristics of the secondary constituent power are to those of the primary constituent power, strong amendment power, the less it should be bound by limitation, including judicial scrutiny and vice versa. Yaniv himself, the guardian of basic structure doctrine, says that if the amendment power has incorporated a democratic process which ensures that people are in some types of amendment involved in participating in the process, then the courts should not interfere. The same is confirmed by Rosalind Dixon and David Landau, who in his case, Transnational Constitutionalism and the Limited Doctrine of Unconstitutional Amendment, state at volume 18, page 2498, another way in which the problem of abusive constitutional amendment can be dealt with at the level of constitutional design is via the use of some form of tiered amendment procedure. A system of a tiered amendment threshold has become as part of comparative constitutional state of the art. Many new constitutions include different amendment rules for different parts of the Constitution. That is what our Constitution has done. Yet, we are now being restricted to operating the Constitution in the context of decisions predicated on a single track amendment power under the repealed Constitution. Indeed, the tiered amendment provision was what was recommended by the CKRC in their recommendation, and then included in Article 1 and 255(1) and 255(2). Now, the third issue, which was raised in support of that position, was that the word amendment is restricted in scope and can only mean limited correction and or modification within the existing structure of the Constitution without fundamentally changing its nature in the Kenyan Constitution. The word amendment in the Constitution cannot be the only word which is fixed in stone under this Constitution, despite Article 259. It has to be read in the context of Article 255, which provides on how amendment is provided, Article 256, which gives the role of Parliament, Article 257, which gives the roles of popular initiative, and people's participation and discussion and a referendum as incorporated in this article. Read in that context, it is beyond what is being said. Now, does the court have power to review amendment provisions? My humble submission is that the court has powers, but that power is limited to ensuring that the provisions are restricted to what has been provided for under the Constitution. Can the court prescribe the manner in which constituent power can be exercised as it did in this case? It is an accepted constitutional principle that primary constitutional power can neither be regulated nor restricted. It is contended by Professor Richard Albert that there is power to revert to the original configuration where a constitution does not provide the provisions for its dismemberment. And he calls this the principle of mutuality in his article, Constitutional Amendment and Dismemberment. But this can only happen as a default provision where the Constitution does not provide for the amendment of those entrenched provisions of the Constitution. However, it is not in accordance with constitutional principle of not interfering on primary constituent power because it creates an extra-constitutional nature, thereby regulating the constitutional procedures which the people have and which is unlimited. And you will find this in an article by Yaniv Rosnai called Constitutional Amendment and Fundament. It is at page 2620, volume 10 of our list of authority. In conclusion, the basic structure doctrine is a constitutional theory which limits the amendment powers by the secondary constituent power. The doctrine, however, cannot be invoked to override an express design of a constitution which incorporates the power of the people through a multi-track amendment procedure in which they participate. This is what has been incorporated in our Constitution by Chapter 1, Chapter 16, Article 259, and particularly provisions of Article 255, 256, and 257, a strong amendment power for that purpose. In my humble submission, I therefore submit that the learned judges, both in the High Court and the Court of Appeal, erred in finding that the basic structure doctrine applies to Kenya. I'll very quickly go through issue number 7, and that is whether interpretation of Article 257.10 of the Constitution entails or requires that all specific proposed amendments to the Constitution should be submitted as separated and distinct referendum questions. And on this I say, the said articles require that a bill for a matter specified under Article 255.1 proposing an amendment to the Constitution be submitted to people in a referendum. It is provided that before assenting to such a bill, the President requests the Independent Electoral Commission and boundaries to conduct a referendum for approval of the bill. What is submitted is not a question, but the bill, either to be approved or not approved. The rules under which these have to be carried out are required by law to be articulated by Parliament, and that is at Article 82(1)(d). The only legislation currently dealing with referenda is Section 49 of the Election Act, which places the burden on the IBC